Okay, now we'll discuss about copyright issues in digital medium. Copyright in digital medium. Okay, when I discussed about the copy part, so copy you understood the copy can be made by means of physical copy. Now, electronic media has made us to make a copy called, we are considering the e-copy. Okay, right of the copyright owners is not restricted with reference to the physical copy. Its rights also come in the form of e-copy or electronic copy, or sometime you call physical copy, and say copying on electronic media. Just like say if I asked that you are storing some article in your PC, and that is storing on hard disk, and you are browsing some article on internet, that is two part. So one is called temporary storing, sometime we call temporary recording, something is stored on RAM, and something is stored on permanent device, that is the hard disk. Okay, considering that part, just like say understood that internet or electronic media has make the world or copyright owners or copyright work more vulnerable to copy or reproduce. Okay, on that context, the copyright on digital media, digital medium, we have chosen that topics. Okay, copyright on digital medium. You have heard about that Indian Copyright Amendment, considering that digital medium and its need, and you know the Digital Millennium Copyright Act, you world WCT copyright or phonographic treaty, WCT, those kinds of treaties, and that lead to the amendment of Copyright Act in respect of India also. Okay, considering all those aspects, that to consider all those aspects, we are taking the topics is copyright in digital medium. Okay, what are the different issues that what I try to mention is that issues related to the digital content or digital copies, databases, social media, just like say nowadays social networking sites, similarly Google, YouTube's kinds of situation, and similarly another part you are coming to for copyright context, and the copyleft doctrine, just like say or another part is coming up, open source licensing, although that their copyright issues are limited, licensing issues are more, there is a business tools. Okay, so issues related to digital content or databases, there is important parameters, just like say what will happen to the copyright work if it is something stored in an or copied in electronic medium. Okay, it is easy to copy. Then so understood that this is information copyright owners and social networking sites, two context. They are using the copyright protected work, they are using the copyrighted work, they are not aware of the situation how much they can use, how much they can use, how much copyrighted work they can use. Okay. That the different issues are coming in respect of copyright in a electronic domain, specifically internet domain. And we also we have to say there is also a business motive for running the social media or social networking sites in respect of copyrighted work. Okay. So considering that part, what way we will create a provision that way that we can create business out of the copyrighted work through by means of social networking sites and also ISPs, internet service provider. By virtue of that, we can spread the knowledge with reference to the copyrighted work, making it easily available or accessible to the public. And on the other context, we have to protect the rights or interest of the authors and owners. Okay. So this is coming up within the purview of digital media and copyright, so Digital Millennium Copyright Act. So there, say, how can you make a balance between that rights and how can you create business out of that. Okay. So considering that aspect, the digital copyright in digital medium are there. So there issues are coming up, management and administration, how the and in copyright part will be managed and administered in digital media. Okay. What can be considered infringement in the digital medium context, and how that can be managed properly for business purposes of the social networking site. So here the different terms have come up, just like say circumventing, anti-circumventing. Okay. What you try to mention on that part, just like say now the copyright work also can be protected in a digital context by means of some technological means, sometime we call encrypting or watermark kinds of situation, some security keys or some algorithm is designed. So these are the technological measures the copyright owners can adopt in respect of digital in respect of copyright in a digital medium. You understood? So he can use some technical protection measures for to protect the copyright work in the digital medium. Why? So understood, just like say he want copyright protection of those class of work, and he is taking some technological measures to protect that work. Now say somebody is circumventing that technological measures, whether he will be liable for copyright infringement or not. Okay. And say understanding say so just like say example, take it, he created a barrier for infringer to to enter on that domain, then somebody is violating that. So okay. So just like anti-circumventing provision, it states that any person who circumvent an effective technological measure applied for the purpose of protecting any of the rights conferred by this act with the intention of infringing such right shall be punishable with imprisonment which may extend to 2 years and shall also be liable to fine, that I am telling with reference to the US part. So, that one part is, so provision state that any person who circumvent, that circumvent means that technology can encrypt or decrypt or say some firewall they have created. Those are technological measures adopted for what purpose, or for adopted measure applied for purpose of protecting. So, in internet domain, in electronic domains, some cases you find out just like a Google Books. Okay. So, Google Books also may protected by means of some technological barriers, so it cannot be downloadable. Okay. So, they are adopting some technological measures to prevent somebody to make or download or copy those books in respect of his copyright. Now, somebody break that algorithm and try to download that book. So, he is adopting a anti-circumventing. So, he is adopting an anti-circumventing means to break his technological part. So, in that case he will be liable for copyright infringement, that is referring within the purview of DMC, Digital Millennium Copyright Act. So, there also Indian Copyright Act recent amendment also suggested the anti-circumventing provision. Then another part I should know about take down notice. So, some cases ISPs or social networking sites is keeping some copyrighted protected work or say some pirated work. So, then if they have been served a notice for take down, so they have to remove that copyrighted work. So, take down notice is another important term in respect of copyright in digital medium. So, similarly, safe harbor a provision have been created for the online service provider or ISPs, specifically including social networking site. So, understood they are now safe harbor means, let us say sometime we consider that dock where the ship say ship is in the harbor, ship for dock where the ship stays for longer time, we can consider that is the safer side for the ship. So, that is called safe harbor. Similarly, so safe harbor provision just like where they will be considered safe, by that means we cannot say other area they are unsafe, but they have created a provision for safe harbor means, let us say where they can say consider they are safe. The 4 safe harbor provided by the Congress, US Congress with reference to that in the following subsection of 512, that transitory digital network communication. Okay. Transitory digital network communication, transitory means temporary, we understood digital network communication. System caching is one of the portion they have mentioned. Information residing on systems or network at the direction of users, they are keeping the information on the direction of the user. Information location tools. Okay. So, those are the provisions they have created on the safe harbor part. Similarly, transitory digital network communications, considering that a service provider shall not be liable for monetary relief or except as provided in just like for injunctive or other, that they have referred for transitory digital network communications. Similarly, they have explained with reference to that systems caches and other sorts of elements as a limitation on liability on respect of non-profit educational institution. They have created a say if something is non-profit educational institution, they have created a limited provisions also. Okay. So, these are the say it's just like say in respect of our digital medium and copyright or DMCA provisions have been incorporated, say the circumventing or anti-circumventing part, safe harbor provisions, all those things have been come within the purview of digital medium or digital millennium copyright act. So now what are the things is coming up in respect of digital medium and copyrights. So issues are coming up that it is digital medium, it is easy to copy something in a digital medium, and internet make the system easier to communicate beyond a particular territories also. Okay. So say now internet or e-commerce or social networking site as an important means of business. Okay. So important means of business. So now how that business is allowed to grow, keeping them some safe harbor provisions. Okay. And also how that make that copyright protection more stringent in respect of internet or electronic world, keeping that anti-circumventing provisions. Okay. So these are the major elements of the copyright in the digital medium. Okay. So now I will analyze some of the elements of copyright infringement in digital medium. Okay. And also I will analyze the little bit on the respect of open source software copyright elements. Okay. So now let's say analyze the case of Baji.com. It is also a case for IT law and respect of copyrights. So just like say he had kept some obscene photograph that is coming by virtue of IT Act. And now whatever way we are discussing earlier, if we consider Napster's case, Ghost's case, just like say copying and just like a P2P sharing that thing on internet, then liability is coming up. Just like say you yourself is not committing the infringement, but doing that act. Okay. Then that liabilities of the person who is sharing that components. Okay. Just like say for Google's and YouTube that take down notice, if they have to do sufficient due diligence exercise time to time for escaping the liability under the secondary copyright infringement. So if some pirated content they are keeping, so they are taking the facilitating that infringement work. So immediately if they came across or somebody found send a notice to them, so they have to immediately remove that thing from their content. So otherwise they will be liable. So you know that the various cases of Google's and YouTube's in different jurisdiction in respect of copyright infringement. Okay. So just like say, so in respect of ISP, how they are liable for secondary copyright infringement, these are the issues with respect of copyrights. Okay. So copyright infringement in digital world in another area in respect of copyright issues and in the digital mediums, and you will get a series of cases. Similarly, the issues of copyright infringement in digital medium is coming up. I will later on analyze with reference to trademarks also by virtue of say linking and framing. If you frame the content of somebody's website in your website, and that website is also, let's say, commercial website, then also you will be liable under the copyright infringement. So framing of some websites content in your website and that using for communication to the public purposes, means internets, definitely, then also you will be liable under copyright infringement. So similarly, providing link in the form of say surface link and deep link. There is also issues with reference to the copyright infringement. If you provide link of another copyright protected website, then also the issues of copyright infringement may come up. So, what are the copyright infringement in respect of digital medium? We can thought about say linking, framing, then let's say the liability is coming by virtue of secondary copyright infringement. Secondary copyright infringement. Okay. So, now the digital medium, one component is the infringement of copyright in digital medium. Another component you are getting that how anti-circumventing and safe harbor provision, the management and administration of the copyright in digital medium. That is the important parameters. Okay. So, now we have some time. So, let's discuss about that what is open source software and copyleft doctrines, specifically as it is applicable with reference to that digital content, just like say source code open. This is sometime we call another community, just like say so for the development of software specifically we are creating this mechanism, a licensing mechanism, different types of licensing mechanism, just like say whatever way conditions you will take the software from a particular open source thing, you have to licensed back that software to that service provider under the same terms and conditions. So, do you think that that software in the open source part is not coming within the purview of copyright? So, definitely that is copyrighted, but they are not that is they are using it in different context in the form of different mode of business as a licensing mechanisms. They are using for what? For further development and for further development. So, now if I ask that question, if you use some software from open source and try to create a proprietary software out of that, then whether that is come within the purview of copyright protection, that depends upon the situation to situations, that how much you have taken from that particular software, and as per norm that is also came definitely will be considered as a copyright that your software code you developing, but you may have to license back the further improvement to that particular open source communities. But as you have you have agreed to the terms and conditions of that open source licensing terms and conditions, or of that or the terms and condition of the administration of that open source. So, you have to follow that things, otherwise you may be liable, you may be breaching the terms and conditions, Okay. So, another part in respect of say digital medium and respect of copyright is a copyleft doctrines we call it, and open source software in respect of software in that digital medium specifically. Okay. So, there are various say the part we are trying to address in this class specifically, say the issues of copyright, challenge of copyright in the context of digital medium specifically, just like say that the challenge to the copyright owners, challenge for the enforcing agency, challenge for the challenge for that challenge for administration and management, for what? Administration and management for better utilization of that copyrighted work. Okay. So, now as we are ending the copyright module in this week, So let's summarize the whole week's discussion within 2-3 minutes. Okay. So emerging issue is that whatever we discussed now, that copyright and digital media specifically, but whatever we learned in this week is very important for the students, teachers, and users specifically. Basically, so we learned about what is copyright. We learned about what are the different categories of work coming within the purview of copyright. Then we learned about the criteria that work should meet to get copyright protection. Then we learned about the authors and owners. We learned about the time frame of protection, life plus 60 years for the literary work and artistic works. What is artistic works? Just like a painting, sculptures. We learned difference between cinematographic film and dramatic work. We learned about related rights. We learned about copyright infringement and fair use. We have not discussed about the copyright protection in respect of international part. Let's just learn that part. Just like if you that is a international copyright protection is governed by Berne Convention. India is a member of Berne Convention. So if you create a work in India or published a work in India, then your works should be protected in all Berne Convention member country. Or if your government creates some reciprocity arrangement for any other country, then your work also will be protected in those country where India government has make a reciprocal arrangement. So international copyright part, you understood that okay, by virtue of its creation or registration or publication in India, your work will be protected in all Berne Convention member countries. So this is the international copyright regime, Berne Convention. Then there is also the different treaties there, WIPO copyright treaties, then performance phonographic treaties, performance for. So these are the treaties that lead to the digital millennium, the Digital Medium Copyright Act protection. Okay, so all those things you should read very carefully because we have discussed in a week almost 2 semesters subject. So you have to be say more thorough about it. Thank you.